We'll go ahead and call this hearing to order, and I want to thank all of our witnesses for appearing here today. Some of you come a long ways, and we appreciate that very much. The purpose of today's hearing is to examine the proposed rules and case decisions by the National Labor Relations Board and the Department of Labor related to employer and employee rights in union organizing drives. This committee has kept a particular focus on federal regulations and policies that are adding to the array of uncertainties confronting small businesses, particularly when those uncertainties add to the nation's stubbornly high unemployment rate. Republicans and Democrats agree on the principle that businesses need certainty if they're going to grow their businesses and add jobs. President Obama has widely touted an executive order directing government agencies to identify and cut the red tape that's out there. He's also ordered agencies to do more than the bare minimum required to ensure that stakeholders have an opportunity to communicate their views on agency regulatory actions. If this is the intent of the President's executive order, it has been put into practice. Rather, the NLRB and the Department of Labor proposed the imposition of new regulations despite the lack of any demonstrated need for changes to existing law and practice. The current NLRB board has been particularly activist in its agenda. There's the infamous NLRB decision to prohibit Boeing from opening a plant in the state of South Carolina. And while this decision does not directly impact small businesses, many of those in the small business community are claiming such decisions are indicative of the NLRB's overall bias against employers and the level of favoritism it's granted to unions. Today's hearing is going to focus on 4 examples of this administration's union favoritism: the NLRB's decision in the Layman's Gasket Company and Specialty Hospital of Mobile, the NLRB's proposed changes to the union election process, and the proposed rule from the Department of Labor regarding the advice exemption to the Labor Management Reporting and Disclosure Act. I'd also be remiss if I didn't mention the NLRB's final rule requiring employers to post notices in their businesses informing employees of their right to unionize. I understand this has been particularly irksome to small businesses who object to what they view as an unwarranted federal intrusion into their business, as well as their objection to the biased nature of the notices themselves. Again, I want to thank you all for being here, and I'll turn to Ranking Member Velasquez for her opening statement.
Thank you, Mr. Chairman. For America's small businesses, employees are their most important asset. While this has always been the case, it has never been truer than it is today. In a globally competitive economy, small companies often succeed and fail based on the talent of their staff, who can help invent a new product, develop an innovative service, or just discover a better, more efficient way of serving a client. For America's entrepreneurs, their employees are central to their strategy and critical for firms' long-term growth. For these reasons, the vast majority of small businesses enjoy strong relationships with their employees. Indeed, I will submit that for 99% of small firms, relationships between management and employees are cordial and not adversarial, regardless of whether the business's workers are organized or not. This record is particularly remarkable, given just how many Americans work for small enterprises. Half of the U.S. private sector workforce is employed by small businesses. 44% of our country's non-farm payroll can be attributed to small businesses. Most of us get our first job at a small enterprise. Considering the enormous contributions small companies make to U.S. employment, the positive history of employee-employer relationships at small firms is especially not noteworthy. In those instances where there are disputes, the National Labor Relations Board exists to help mediate. The structure provides a proven channel for resolving labor disagreements. The board works to protect the rights of both employees and employers. With so many Americans, entrepreneurs, and employees counting on NLRB to serve as a fair conduit for resolving labor problems, it is critical that the board operate as efficiently and effectively as possible. Several recent steps outlined by the NLRB to improve its election process will further that goal. Allowing filings with the board to be submitted in electronic form is common sense. In today's Internet age, It only makes sense that this option be available to those seeking redress, be they employees or employers. In addition, putting in place standardized timeframes for the resolution of disputes will add certainty to the process for all participants. Streamlining the appeals process will also cut down on unnecessary red tape. On their face, these seem like logical efforts to make the NLRB work better for everyone. This committee often hears about the need to streamline government institutions. If we were discussing environmental regulation, tax compliance, or workplace safety issues, reducing paperwork and setting deadlines for agency action will be universally applauded as efforts to lessen the burden on entrepreneurs. However, when those steps might facilitate hardworking Americans organizing a union, there seems to be a hue and cry from the other side of the aisle. This position strikes me as inconsistent at best. Mr. Chairman, the vast majority of small businesses in our country enjoy warm relationships with their employees, and in fact, most of them will likely never need to make use of the NLRB. However, when problems arise, it is important that fair, workable processes be in place. It is my hope that the NLRB step can improve the system for all participants, employers and employees. And I thank the witnesses for being here today and sharing with us your insight on this issue. Thank you, and I yield back.
Thank you.
Mr. Chairman, if I may, I just would like to introduce for the committee our newest member, Janice Hahn, and I would like to welcome her. And she represents California's 36th Congressional District. While new to Congress, Ms. Hahn has a long history of public service, having served on Los Angeles Charter Reform Commission and the Los Angeles City Council. I'm sure her experience working with California entrepreneurs will prove useful as she serves in this committee, and I welcome her. Thank you.
It's good to have you on the committee. Thanks for choosing us. Our first witness is going to be Elizabeth Melito. She serves as the Senior Executive Counsel for the National Federation of Independent Business Small Business Legal Center. In her capacity as a Senior Executive Counsel, Ms. Melito frequently counsels businesses in areas of human resource law. Ms. Melito, welcome. And I might explain, too, real quick before you get started. The lights are set up for 5 minutes a testimony, and when you get down to 1 minute left, it turns yellow, and then when it's over, it turns red. We're not going to break anybody's arm if you go over time, but try to keep, if you can, keep it within. But again, thank you all for being here, and Ms. Melito.
Thank you, Chairman Graves, Ranking Member Velasquez, and distinguished committee members. Thank you so much for inviting me to be here with you today. My name is Elizabeth Melito, and I serve as Senior Executive Counsel with the National Federation Independent Small Business Legal Center. NFIB's mission is to promote and protect the right of its members to own, operate, and grow their businesses, and it represents 350,000 businesses nationwide. The typical NFIB member employs 10 people and reports gross sales of $500,000 a year. The NFIB membership is a reflection of American small business, and I am here today on their behalf to share a small business perspective with the committee. Currently, small businesses in this country employ just over half of all private sector employees. Small businesses pay 44% of total U.S. private payroll, and small businesses generated 64% of net new jobs over the past 15 years. Small businesses are America's largest private employer. And for that reason, we applaud the committee for holding this hearing and highlighting the exceptional problems that labor rules can place on small businesses. Suffice it to say that labor law is difficult to understand. Even experienced labor lawyers struggle to keep up with the ever-changing legal landscape. Imagine then the challenge facing America's small businesses. These are businesses that are run by men and women who struggle day to day simply to make ends meet. They typically have no administrative staff, little human resource expertise, and certainly no regular access to legal counsel. Today's small business owners contend with anti-discrimination laws, family, medical, and other protected leave laws, wage hour laws, privacy laws, workplace safety laws, tax laws, environmental laws, and of course labor laws too. They struggle to decipher these overlapping and sometimes even conflicting federal, state, and local laws. And again, the problem is compounded by the fact that small businesses rarely employ a dedicated HR, labor professional, or other compliance staff. Today I will discuss how DOL's Persuader Rule and NLRB's Poster Rule will impact small business. In my written testimony, I have explained in greater detail how these rules and other changes by DOL and NLRB will affect small business. Imagine for a moment a man named Randy. He's a plumber in Illinois who worked for himself for years before deciding to hire a few assistants to cover growing demand. Randy serves as CEO, president, treasurer, HR VP, CFO, frontline supervisor of his company, all while working as a plumber on a daily basis. One day, Randy gets approached by someone identifying himself as a representative from the local plumbers union. He tells Randy that 3 of Randy's 4 plumbers want to be represented by a union. Randy doesn't know much about unions, but he knows he doesn't want a union representing the 4 plumbers he employs and works with hand in hand on a daily basis. Should he talk with the employees? What can he ask them? What can he tell them? What does Randy do? Well, today Randy might call NFIB, or I'd direct him to call an experienced labor attorney ASAP. The attorney then becomes a business partner, helping Randy's business through the maze that is today's field of labor law. It is this partnership that is a grave risk due to DOL's proposed Persuader Rule. Under the new Persuader Rule, all actions, comments, or communications that could have a direct or indirect object to persuade employees would be reportable to DOL. This includes virtually everything that a labor attorney would do for his client, whether or not there is union organizing activity going on. The net result of the new proposed rule will be that lawyers and law firms may no longer be willing to offer advice to employers about labor matters. We fear that this proposal will limit small employers' access to counsel on most aspects of labor law, an area where legal advice is sorely needed. NLRB's recent actions will also greatly impact small businesses. In August, NLRB ordered small businesses to display a poster instructing workers on how to form unions. It did so despite the fact that the law creating the NLRB gives it no such authority. The notice posting rule, which will become effective on November 14th, imposes an unfair labor practice on any employer that fails to post the notice. On September 30th, NFIB filed a lawsuit challenging NLRB's intrusion in the workplace. We've asked the court to overturn the rule and declare that NLRB lacks statutory authority to require such a posting by 6 million private sector employers. NFIB's members are honorable and fair employers, and I do believe they have warm relationships with their employees. But they are troubled, confused, and scared by the avalanche of labor regulations and rules coming out of DOL and NLRB. Why should anyone care how these government entities treat small businesses? This question can be answered in one word: jobs. Jobs are what Americans want and need, and most jobs in America are created by small businesses. This tidal wave of new rules will do nothing but crush small businesses and further prolong America's economic woes. Thank you very much.
Thanks, Ms. Melito. Next, we're going to have Mike Mittler, who's the co-owner of Mittler Brothers Machine and Tool, located in Wright City, Missouri. The company manufactures tools commonly used in auto racing and the aviation industry. Mr. Mittler started his business 30 years ago with his brother Paul, and it remains a family-run business. Mr. Mittler, thanks for being here. Appreciate you coming in.
Thank you, Chairman Graves and Ranking Member Velasquez, members of the committee. Thank you for the opportunity to testify today. My name, as you said, Mike Mittler, President and co-founder, Mittler Brothers Machine and Tool. We're located in Wright City, Missouri. My brother and I founded the company in 1980 in a 2,500 square foot wreck of a rented building with just Paul and I as the only employees to start with. We started with an idea and a commitment to hard work, and now 30 years later we have 60 employees and a diversified business, including a product line of metal fabricating tools serving the auto racing, hot rodding, and aviation market. Our job shop customers are leading companies in their industry, including building products, energy, automotive, and industrial lasers. We have a mix of both senior and junior employees, including my brother Paul's daughter, our second generation, working in our plant. Our average tenure is over 10 years, including 9 employees with over 20 years of service. We have 2 other sets of brothers and 1 husband and wife team working for us, making us very much a family operation. There are only 3 very simple rules at Mittler Brothers: safety, quality, productivity, no exceptions. We are proud to have over a 5-year record of no lost time accident in our plant, which exemplifies our commitment to safety. In 30 years of business, we continue to meet and exceed federal workplace standards. We do this not because we are forced by federal regulators, but because as a small business, our employees are our family, and it is just the right thing to do. Just like the millions of small business owners like us, we know that a safe and happy work environment leads to a productive and profitable company. In the past 31 years, OSHA has come into our shop twice on campaigns aimed at our industry. Both times when minor infractions were found, we immediately took steps to correct those and worked with the agency inspector to ensure full compliance. Historically, manufacturing businesses in our industries maintain good working relationship with inspectors and regulators with OSHA, the NLRB, EPA, and others. Our trade industry groups, such as the National Tooling and Machining Association, which I chaired in 2006, worked for years with various agencies to help set and monitor industry safety standards. However, the past few years, we have noticed a significant shift in the way federal regulators approach their relationship with manufacturers. It feels like we have moved from an environment of cooperation to one where agencies have a gotcha attitude. In the past, an inspector would visit your shop and work with us to correct any unintended violations. Today, they fine you first and take no questions later. In the past several months, the NLRB issued a string of decisions and complaints with broad implications for employer-employee relationship. For example, the decision against Boeing Company, as the chairman noted, has the federal government targeting a private business to choose for increasing manufacturing employment and production at one of their facilities. How does that look when we're trying to strengthen manufacturing in America so we, small suppliers, can still have customers? Recently, the NLRB expanded a requirement mandating that all private employers must place a poster in their businesses notifying employees of their rights under the NLRA to join a union. It continues to astound me when the government takes the approach that the only way to a better, safer, and happier work environment is to join a union. For small business, it is quite the opposite. Employees have the freedom and flexibility to be partners with the owners and to get the job done right and get it done fast. Add the poster rule to the new quick election process the NLRB is imposing, and you begin to create a more hostile work environment where employees and employers no longer feel they can openly communicate. In addition to the direct impact the NLRB has on my company, it is a greater impact to my customers. If those larger manufacturers for whom my employees make parts close their doors due to a hostile environment for manufacturing companies, all the families at Mittler Brothers will suffer. We are hopeful the administration was taking a new approach to regulations when the President in January 2011 issued an executive order requiring all agencies to conduct a full review of the impact and effectiveness of new regulations. Since then, the administration has withdrawn new regulations from OSHA requiring businesses to implement new noise-canceling equipment if they were feasible or capable of being done, regardless of their effectiveness. They put on hold new EPA regulations. There may yet be some signs that Washington might revert to a culture of cooperation with employers. Unfortunately, it seems the NLRB missed the President's memo. I came to Washington today because I want to fight for my employees and my company. I came here today because I thought it was important that policymakers in Washington understand how small businesses work and the excellent relationship we have with our employees. We are local small businesses who seek local solutions in a community where we often have multiple generations working at the same manufacturing plant. At a time when manufacturing is leading the way for our economic recovery, we need Washington to make us more globally competitive, to promote a positive workplace, and to strengthen manufacturing in America. The latest actions by the NLRB do the opposite and will create animosity in the workplace without helping those we seek to support, our employees. Thank you for the opportunity to present testimony today. I look forward to continuing to work with this committee as I have in the past on issues from supporting automotive suppliers and workforce training to the regulatory burden on small business. Thank you.
Thanks, Mr. Mittler. Our next witness is going to be Beverly McCauley. Ms. McCauley is president of Hunt Country Masonry, located in Leesburg, Virginia. She started her business with her husband in 2006 as a side business to support a growing family. But due to the economy, it has now become her full-time profession. So welcome.
Thank you all for inviting us here today. It's important that you hear from all sides. So again, my name is Beverly McCulley, and I'm a co-chair also of the Legislative Committee of the Mason Contractors Association of America. I come before you with 22 years of experience in small business. As a small business, we already have enough uncertainty with taxes and laws. And the changes that are being proposed and enacted by the NLRB and the DOL, I feel compelled to share from a small business standpoint what caveats these cause. These changes are first being instituted at a point in history when unemployment is rampant. Case in point, in 1935, the Wagner Act was passed, and in 1937, the Supreme Court upheld the decision. The result, a depression within a depression, when efficiency and profitability are removed from the equation, and when everyone is rewarded equally, regardless of productivity and skill, then productivity and skill diminish, and the result is decreased profitability and increased unemployment. This act influenced the culture into the 50s until the right to work prohibiting forced union membership arose. With the right to work, a not-so-surprising result. Profitability increased, and so did jobs. For you see, when you make everyone stand on their own merit and make everyone responsible for their own destiny, an amazing thing happens. People begin to take ownership for their destiny. The hardest workers were paid based on their productivity, and the less productive workers earned less based on their performance. But they still had a job. So the end result, you pay less if someone works less, therefore reducing unemployment and increasing profitability and increasing the jobs available. Congress knew where this was headed and refused to pass the Employer Free Choice Act. Congress realized that sweeping changes had the potential to transform what could be a recovery into the next Great Depression and exponential unemployment. At this point, it's not a far stretch to picture us headed in that direction. The Employee Free Choice Act is being touted as the best scenario for all involved. It eliminates secret ballots. We get the same right when we vote for any of you located in this room, the right to vote in private. If we change the system to open voting with no secret ballots, the meek may be influenced out of fear. It seems imperative to me that we continue to have the right to vote in private. We fight for this right every day in the name of democracy, the right to vote in private, yet in our own country we're going to deny someone that same right? At the same time, the employer, prior to all this, does not have the right to express the downsides or even set the record straight without fear of retribution. I'm sorry, I don't feel like jobs should be sacrificed for political paybacks to ensure future political support. That brings me to the next point. Unions don't let you know that you have the right to say no to union dues associated with a political agenda. It seems like the reason behind the Employee Free Choice Act is to elicit a fear of the unknown in already uncertain times. The NLRB would have you believe they are the big brother looking out for the younger sibling, when in fact it's big government attempting to collect dues to pay off and support more like-minded people to fund the agenda, that employees need someone to take their money and redirect it in the right ways and call it union dues. That makes me really want to work harder, or does it make everyone want to work to the level of the employee that's skating by and earns the same amount of money? Excuse me. They want to exacerbate the problem by allowing micro-unions and gerrymandering with the same company. So one group in the company can be unionized into one group, another into another group, and so on. You could have one machinist working side by side, each in a separate union. Furthermore, the NLRB and Department of Labor have a proposal that will require all employers to release to unions any and all contact information they have on each employee, post on sites detailed notices outlining how to organize, giving context for the NLRB, but nowhere is it posted whom to call if you're harassed, lied to, or coerced. So we have an organization that wants the rights to all our information, but you have no recourse to stop them from calling and no way to vote privately, essentially making it impossible to stand up for most people. I'm not most people. My husband and I are raising 5 children. I'm co-chair of a legislative committee. I'm also president of a small business. I'm not afraid, but what does frighten me is that they have the right to destroy our great nation. This will cause double-digit unemployment. How does that all affect us? Less money for the federal government because no taxes are being paid, which exacerbates the deficit, which causes us to have further arguments over budget cuts. Less taxes paid, more programs are cut, more people lose their homes. As you can see, we're faced with a slippery slope that only gets slicker the more power they elicit. Congress was right when they refused to pass the Employee Free Choice Act. However, the NLRB and DOL are essentially leaving Congress and the American people out of the loop and taking employees' ability to make informed decisions out of their hands as well. Without every able-bodied American working that is able to work, we cannot recover from our debt. In order for everyone to have a job, we must have a community that believes that everyone should be paid based on their merit. That's why we are a free society. Unions had their place decades ago to make for better working environments for employees. Times have changed, and unyielding power is not the answer. So if we want to get this country rolling and out of our trillions and trillions of dollars of deficit, everyone needs to work and be paid for the work they do at the level they perform. Thank you, and I really appreciate your time to let America's voices be heard, for this is truly a great nation. Let's get the ball rolling and get on the right direction. Thank you.
Now it's my pleasure to introduce our next witness, Mr. Alan William West, Jr.
Chair.
Founder, president of the West Metal Company, located in Sterling, Virginia. I didn't, well, after, after serving in the United States Army and learning his trade in a certified apprenticeship program, Mr. West went on to found his company in 1983. The West Metal Company installs and fabricates heating, ventilation, and air conditioning units for high-profile clients such as Lockheed Martin. Mr. West's small business currently employs 46 workers. Welcome, sir.
Thank you. Chairman Graves, Ranking Member Velasquez, and members of the committee, thank you for your invitation to appear before you today. My name is Alan West, but I'm known as Willie to my family, friends, and business associates. I'm the owner and founder of West Sheet Metal Company located in Sterling, Virginia. My company currently employs 45 sheet metal workers and office staff combined, but I've employed as many as 70 sheet metal workers. My company installs, fabricates heating, ventilation, and air conditioning duct systems, and we do work for high-profile clients such as Lockheed Martin and Howard Hughes Medical Institute. I started the company in 1983, but I learned my trade in a certified program, apprentice program operated by the Sheet Metal Workers International Association, Local 102. It's now Local 100, which represents the sheet metal workers in Virginia, Maryland, and the District of Columbia. I've started the apprentice program for the Sheet Metal Workers International Local Union 102 in 1968. Then I left to serve in the United States Army. Following my discharge as a specialist 4th class and being awarded the Army Commendation Medal, I resumed my apprentice training. After I completed my 4-year program, I became a journeyman and started work for Wilco Sheet Metal in Rockville, Maryland from 1973 to 1983. I left Wilco to start my own business in 1983. From the beginning, I wanted to provide good-paying jobs, solid jobs for sheet metal workers, and I wanted to employ well-trained and well-skilled sheet metal workers. So I entered into a signed agreement with Sheet Metal Workers International Local Union 100, which of course was formerly Local 102. I view my workers as an integral part of my business and an important asset in its success. I wanted to partner with them through their union, and the collective bargaining agreement helps me do that. The theme of the contractor and union partnership is "Together we do it better," and I know that to be the truth. As a signatory to the agreement, I use the local union's hiring hall. When I need workers, I call the hiring hall and describe my needs. They refer skilled, trained workers. I know that these workers have undergone a rigorous and thorough training program through the apprentice school that the local union operates, and I have confidence in their abilities. In addition to the local union joint apprentice committee, there is a national organization, the International Training Institute, that sets all the training standards for sheet metal workers and also establishes curricula and programs for apprentices and journeymen to upgrade their skills. This training is free and is offered on evenings and Saturdays. This training program ensures that training is consistent all across the country so that whenever I have a project, I have access to skilled and trained workers. I also want to make sure the jobs I'm creating and providing are good jobs that can support a family and help workers be successful. Through the union contract, my workers participate in a health care plan and a pension plan. In making contributions to these plans and by combining with other union contractors, we're able to achieve a high level of benefits with cost savings. In addition, I do not have to hire people to administer the plans, deal with such issues as health insurance or retirement programs. The International Union also sponsors the National Energy Management Institute that sets standards for energy efficiency and air quality and looks at new markets and the training required for sheet metal workers to develop the skills needed for these new markets. For example, I know that welding has remained in demand during this time of high unemployment, and sheet metal workers are able to access training to be ready for these jobs. The Sheet Metal Workers Occupational Health Institute sets standards for OSHA compliance and provides worker training. This in turn lowers my insurance costs, and my workers learn to work safer and enjoy better working conditions. These institutes and training facilities, health and retirement plans are all administered by joint committees of union and company representatives. They help both contractors and workers. All the funds used to provide this training and these benefits and other assistance come from contributions by the parties to the contract, and no government money is used at all. All of these programs are the result of private agreements. What I have described in my testimony is all accomplished within the framework of the National Labor Relations Act. I do not have a lot of personal experience with the National Labor Relations Board, but I know that it governs the relationship between my workers, my company, and their union, and allows us to accomplish these important goals so that I can concentrate on my business and create and provide good jobs in the community. I have reviewed some of the recent decisions and proposed rules by the National Labor Relations Board and Department of Labor, and I do not see how they disadvantage small businesses. They do not affect the framework in which I operate my business and will not affect my business or my relationship with my workers or the companies I do business with. These seemingly minor changes certainly do not create any uncertainty for me, and they will not affect my ability to create jobs. In fact, if the NLRB streamlines its election process, it seems to me that this will reduce turmoil in the workplace and be helpful to businesses, especially small businesses. What I need for my company to survive is more work, and that means more consumers and more buyers. These recent changes by the NLRB and Department of Labor do not affect that in any detrimental way. In closing, I wish to emphasize that I view my workers and their union as a significant driver in my success as a small business owner. We're all working together to be successful. Thank you for this opportunity to talk to you about my business and my relationship with my workers and their union.
Thank you, Mr. West. We're now turned to, I'm going to open up with Congressman West from Florida.
Thank you, Mr. Chairman, and Ms. Ranking Member for scouring the earth and finding another Allen West to be up here in Capitol Hill with me. We got to talk about whether or not your daddy was ever down in Georgia.
I'm a native Virginian, so we're probably...
Okay, we probably are. Which side did your father fight for? Thank you so much for the panel for being here. And this is very appropriate because last week when I was back in the district, talked to our Small Business Advisory Committee and also the Broward County Small Business Advisory Council. And this thing about labor law was something that they brought up. And 2 points that I want to bring up. One was about project labor agreements and the effect that they're having as far as small businesses who want to come in as subcontractors. And then also some issues about labor law with some of the rights of employees who have been terminated or for whatever reason quit, and they're bringing lawsuits back against some of these businesses. So I think it's very important we talk about labor laws and the Department of Labor and their impacts on small businesses who cannot afford to spend a lot of their time and resources with these, some of these frivolous lawsuits. But I think the real question here is not really about the benefit of unions, but the question really has to be about is there an agenda out there that is being promoted that would seek to take away the choice and the option that an employer has as far as whether they want to have the unions to come in. And also, I think it is about that influence being expanded. So what I always like to do is look at trends. And so my question to the members of the panel here is, have you seen trends here within the last year, 2 years, 3 to 5 years, or whatever, of an NLRB and a Department of Labor that has become maybe less of a nonpartisan or a non-arbiter, but is more so now promoting an agenda that you feel may be contrary to your advancement of your small businesses, and maybe you can talk about some other relationship with other small business owners that you have talked to this about.
I'll go first if that's okay. I mean, I would certainly say from the members I hear from that they would agree that there, or would say that there has certainly been, they've seen a trend with the NLRB and DOL not being impartial. Certainly in the NLRB, the intent, and for over 50 years, it was seen as an impartial arbiter between employers and employees when it came to labor disputes. And in the last few years, it certainly has not been that, or the cases that we've seen and the proposed rules, and now the final rule for the posting rule, too, have, I would say, definitely been pro-union. And, if you go to the National Labor Relations Act, I mean, the intent is to arbitrate disputes between employees and employers. Unions are not in there. It's the employees and the employers that we want to arbitrate the disputes between. Our members, for the most part, do see their employees as an extension of their family, and they want to maintain the direct and open communication with the employees, and they really feel that to be the best business they can, stay competitive, it's best for them to have the direct and open communication with their employees without a third party present. Thank you.
Yes, when you look, pardon me, when you look at the poster, as we've been instructed to post it in about 6 weeks, it's 11 by 17 in size, and there's only one line on there that says it has all the things that you can do for union representation and all that, and it only has one line that says, or you may elect to do nothing. So it seems that, if you look at that amount of square inches that we're going to post in our legal posting area, that we only have a very one line that says. It still has not been determined then what communication we can post that says to our employees, hey, we want to continue like we have for almost 32 years. We want to continue that open dialogue. We want to treat you as family. We want to be able to resolve issues that have come up, whether they be pay, whether they be benefits, whether they be anything that comes up. So it appears that with the failure of the card check bill, that this was another way to then impose a stronger union workforce in small businesses.
I'm going to have to agree. Sorry to not break rank or anything like that. I find that when dealing with the NLRB, it seems like every aspect of it is all pro-union. They aren't looking at the larger picture. It's all about their rights. They have the right to get all your information on all your employees. Your employees don't have that right to opt out. Some people have posted and unlisted numbers for a reason. They're hiding from someone that they don't want to find them, ex-spouses, and for any other number of legitimate reasons. And if the NLRB has the right to each and every person's contact, and they want internet contact as well as home phone numbers and home addresses, where is our privacy at? Why do we have to release that without consulting our employees first? And I think once that gets out, and once you have all your employees, it's free game for harassment. There's enough people that call my house on any given night asking for something anyway. I don't need it to be that as well. In addition, I don't think small businesses get a very good rap. The last company I was with, I was there for 20 years. I I solely wrote the apprenticeship standards and had laborers trained in bricklayer positions. No one required me to do that, but it was good business sense for the employees and good business sense for profitability. If I train people the way I want them trained, they're going to work to my standards. I don't think the union does that any better than anybody else can. I think everybody takes an initiative for profitability, and I think when you take that right and that dignity out of an employer's hands, then you are drastically influencing unemployment. Thank you.
First, I'd like to say I think of my employees as a family, too, and most of them have been with me for 20-some years. I do not think that these NLRB rules are anything exceptional. What I have read, most of it is reinstating rules that have been in place previously. I also do not think that the issue of posting their name and address, that was always has been a rule. You've always had to give out employees' name and addresses. The only addition to that is the email and the phone number, if I'm correct on that. So, and I'll tell you, if you have a person's name and address, you can get all the rest of it. So I don't think that's a privacy issue. As far as the posting workers' rights, in my lunchroom right now, there's a big bulletin board, and on it we have OSHA posters. We have posters from our insurance company for work safety. We have the unemployment rules and regulations. This is just another poster, so I don't really see a big issue with that. If, you know, I mean, posting what people's legal rights are does not seem to be anything terrible to me. So that's my feeling on it.
Thank you, Mr. Chairman. Ranking Member, I yield back.
Ms. Velasquez.
Thank you, thank you, Mr. Chairman. Mr. West, are you concerned that recent NLRB decisions and proposed rule will impede in any way your business activities if your employees opted to enter into a new collective bargaining agreement?
I don't really think so, because I've been a signatory with the union for several years, and every 3 years to 5 years we have a contract agreement, and we have to go through negotiations for that. And I would assume the process would be very similar, and I don't see where it would be disruptive.
A statement that we hear constantly in the Capitol and at budget committee hearings regarding the federal government agencies is that they need to do more with less, and that we all have to do more with less, given the budgetary constraints that we're facing. So the board's new rules will allow elections to go forward and leave parties to litigate afterwards. Don't rules that streamline the agency's processes and avoid duplicative litigation serve employers, employees, and government interests?
I would certainly think so. Anything we do in business, if we're implementing a move or buying new equipment, we try to do as fast as we can, keep things to not disrupt our operation. So I would think that streamlining the process certainly would be an advantage, not a disadvantage.
Thank you. Ms. Milito, the NLRB has recently issued decisions that have been unanimous, split on party lines, and sometimes split not on party lines. Further, several recent cases have gone against union interest. For example, in Mizona's Maven Baker, the board found that it lacks the authority to award back pay to undocumented immigrant workers whose rights have been violated. Hasn't the board issued decisions that go against both unions and against employers, and doesn't this indicate the independence of the board?
There certainly have been decisions that have been in favor, they have found in favor of the employer, but I would point to 3 big decisions that came out in August because they were really monumental and I mean, just really trampled on employers' rights, and I think they overshadow, truthfully, other decisions that have been issued by the board this year. In the course of one afternoon, the board restricted workers' rights to the secret ballot election. They undermined the employer's ability to maintain unity in the workplace, and they created new barriers for those who wished to challenge union representation. In essence, they were doing what some of the panelists talked about today. They were bringing in what is almost the Employee Free Choice Act by reversing board precedent. So I would say that these 3 decisions alone really overshadow any other decisions issued by the board this past year that may have been seen as pro-employer.
But the fact that they issue 3 decisions based on the fact that they have taken other decisions that benefit workers and benefit employers, it shows that the board is going to make the decisions based on the facts on the rule and the regulations based on the law. So that doesn't mean that it's supporting one against the other. It's based on the facts that they have at hand. I would like to ask you, you state in your testimony that NLRB, Lamon's gasket decision overturning Dana Corp took away your right to a secret ballot election. However, a small business will still have the right to file a decertification petition. Isn't that the case?
That certainly is the case,
Okay, thank
Ranking
you.
Member Velasquez, but they must wait 6 months now at a minimum.
But you stated that it takes away your right to a secret ballot election, and that's misleading. It's not based on the fact.
I would say it's an unprecedented setback.
Mr. Hanna.
Thank you, Mr. Chairman. Mr. West, the panel in general, I don't think there's anyone here who's saying unions are bad. I don't think there's anybody who would argue. I ran a union shop for almost 30 years. I've been a union member for 25. It's not about whether unions are good or bad or what they provide and what employees or don't. Certainly, they've played a huge role in the advancement of workers throughout our history. Everyone here knows that. You're already a union shop. I would suggest that most of the testimony that you gave today is relatively moot, because you are not affected by any of the rules since you already are a union shop. This affects people who, and employees too, who take fundamental exception to what the Geneva Convention guarantees prisoners of war to have, and that is a secret ballot, unless I'm mistaken. It is about intimidation. It is about unions trying to do somehow through rules and regulations what they have not been as successful through Congress to do, and that is the Employee Free Choice Act. You know, it's not a matter of at all whether unions are good or bad. My personal opinion is they are both good and bad. I had wonderful employees. My union employees are the best in the world. None of that is the point. The point is, does the NLRB have the right to set up rules and regulations which fundamentally change the nature and the negotiating capacity of the businesses at question? And I would suggest to you that that's what they're doing, and that this is the preponderance of evidence is that this is an overreach on their part to try to reinforce people's ability to be unionized, even if they don't want to be. Because when someone can look over your shoulder and tell you or see how you vote or know how you vote in an open ballot, that can cause intimidation. And I, for one, think if people want to be unionized, they should absolutely be able to do that. And I wanted to ask just people in general if they feel that's a fair description, first of all. Secondly, in a world market where we are competing globally, the nature of products that we have to produce, like you do, Mr. Mittler, world-class products, the value-added nature of those should allow people to maintain a higher standard of living, I would imagine. And more skilled employees can demand more money. But the world is changing, and these are difficult times. And I understand people's deep desire to raise their wages and benefits, and I applaud them for that and would love to be a part of that. I just don't see how something like card check advances union causes, or how telling Boeing where they can locate a company when they haven't laid anybody off in their own state, how that advances the country at large or promotes jobs. So I apologize for this diatribe, but Mrs. Melito, what do you think?
I mean, I do generally agree with you. I mean, I think the NLRB in particular, I mean, it's been a gross overreach of power. And in fact, I would argue that some of their actions of late are you know, go so far as to be unconstitutional. And they're trampling on employers' First Amendment, you know, or free speech rights, rather, which I believe certainly the Poster Rule does. And I mean, even DOL's rule that's now going to require the reporting of really any, you know, legal advice received related to labor relations is just going to curtail employers' First Amendment rights of, you know, free speech, which are set forth explicitly in the National Labor Relations Act. And I think that's very problematic that employers' rights under Section 8C are going to be trampled on and diminished by these rules, and it's very problematic.
Well, I was raised in a very simple manner, and I was taught by my father an honest day's pay for an honest day's work. And I clearly believe in the productivity of the employee, and my employees that are more productive receive more pay. And I think that's the way it should be. Those that can help produce more in our three simple rules, safety, quality, productivity, our most productive employees are going to receive the highest pay. So I agree with it. I'm not saying that unions are bad. I'm not suggesting that. I certainly think the right to a secret ballot is absolutely something that has made this country great for well over 200 years, and I don't think there's any disagreement that we want to keep and maintain the secret ballot. As was already stated, each of you was elected with a secret ballot, and if any of us ever chose to run for elected office, we would want to be elected by a secret ballot. So I agree with you completely, Mr.
And I think, too, people should have the choice not to join a union. And that should be just as free and easy as those people who chose to join a union.
That's exactly what I'm suggesting in my testimony.
My time is up. Thank you, Mr. Chairman.
Ms. Chu.
Thank you, Mr. Chair. Mr. West, as a small business owner, you are being asked to comply with these posting requirements, and in fact, I'd like to focus on that aspect of these rules. The posting, of course, requires that these be available to be seen by all the workers, and I have noticed that these can be downloaded for free and is available from the National Labor Relations Board for free. How costly is this for your business to be able to post these kinds of signs?
Well, I wouldn't think you would have to post. I wouldn't think you would have to post too many. You have a free download. Even if you didn't have a big copier, you could go to Kinko's or FedEx, and they'd probably make them for about $2 a piece. So that I don't think it's a monetary issue at all to post a poster. I guess you may not want to post a poster if you didn't want everyone to know their rights, but I don't think that it's a monetary issue at all.
How intrusive is it to your business to post it?
I already post posters from the Unemployment Agency for the state of Virginia, several other state acts. I post OSHA safety posters. I also post injury reporting posters. So I already have a big bulletin board in my lunchroom, and it would just be adding another poster. So it wouldn't be any impact at all.
Ms. Melito, I see that you, of course, object to the poster with regard to the union organizing rights, but you also object to the posters on minimum wage and the posters on OSHA. And I do have the poster on OSHA, and it has such information to the employees, like you have the right to notify your employer or OSHA about workplace hazards, or you have the right to request an OSHA inspection if you believe these are unsafe and unhealthful conditions in your workplace. Do you object to that?
I don't think I said anywhere in my testimony that I objected to minimum wage or OSHA posters. I was talking about the complexity of complying with the laws. As far as the NLRB poster, our argument has been NFIB's, and this is made in our lawsuit too, the NLRB does not have authority under the National Labor Relations Act to require employers to make such a posting. OSHA is given such authority. Department of Labor Wage and Hour is given such authority. EEOC has statutory authority to require such posters. The NLRB has not been given such statutory authority. It's a violation of the Administrative Procedure Act.
That's very interesting. In 1949, actually, the Department of Labor issued a rule requiring a notice posting of employee rights under the Fair Labor Standards Act, and this authority and the rulemaking authority that the NLRB is granted allows for the posting of notices required under many federal labor laws, and have done so since 1949, so there actually is a precedent. Actually, I'd like to keep on going because I actually read also in your testimony that you also target wage hour posters. So we do have this on the record as well, because I read your testimony very carefully. And basically you imply that it's burdensome and costly for workers to be informed by this poster. This is the minimum wage poster. And it says that the federal minimum wage is $7.25 an hour, and that youth 14 and 15 years old may not work more than 3 hours a day on a school day. Do you object to that?
Yes, I do, and I have my written testimony in front of me today, and I talk nothing about posters. I say today small business owners contend with anti-discrimination laws, family, medical, and other protected leave laws, wage hour laws, privacy laws, workplace safety laws, and labor laws. I say nothing in that sentence about posters.
Well,
I think you've mischaracterized my written testimony, and I apologize if you have, if it wasn't clear, but I'm not objecting to the posters from Wage and Hour or OSHA.
In fact, I am curious how much you think it costs to make these posters for employers, I should say.
In our lawsuit, we're focusing on the Administrative Procedure Act violation and the potential First Amendment violation of the forced speech on behalf of employers.
Well, I would like to make it clear that these posters are downloadable and that they are free from the NLRB. And I guess my main question is, how will workers know about these rights if these posters aren't available?
Well, our argument has been that the NLRA, the law, needs to provide the NLRB with authority to post the posters. And right now, the board does not have authority. It would be, impendent on Congress to provide the board with authority to require such posters. And certainly, even absent such posters, there's nothing that, prohibits unions from informing and other employees from talking amongst themselves about union rights and their rights to organize and engage in concerted activity.
In other words, they wouldn't know about their rights.
I wouldn't say they wouldn't know.
Thank you. I yield back.
Mr. Barletta.
Thank you, Mr. Chairman. Ms. McCauley, the NLRB has tried to downplay these proposed rule changes by saying that very few small entities would be impacted by them. Do you agree with that statement?
No, sir, I do not. I think that each and every one of us, when you yield and you give way to one thing, it becomes a very slippery slope where everything can follow quickly thereafter. It's just a foot in the door to get the ball rolling, and then after that, then you have to deal with the circumstances.
As you stated a little earlier, that the NLRB recently finalized a new rule that will require all employers covered by the National Labor Relations Act to post a notice in their workplace notifying their employees of their rights to unionize. Does the board have the authority to require that these notices be posted?
Not in my opinion, do they? I think they've, just like Ms. Melito has said, they haven't been given that authority to post those things, and you don't have both sides adhered to at that point. You're giving one side full reign and the other side no ability whatsoever to react or have a compensation talk with your employees, because the minute you sense something or you say something, then it's always judged, and then you have issues. I've spent many classes on how to make sure your employees are happy, make sure they're productive, and I think the union, you're always going to have people that work harder because it's their destiny to work harder. They were raised in a certain way that it's important and imperative to them to be a profitable person in the economy. And you have other people that are just going to get by. I have 4 boys. I cannot tell you the difference between each and every one of them, but I know which ones are my slackers and which ones are just going to do it right. So there's that same thing in the economy and in every step we take. And I think if we put everybody in a category that says, you do this job, you're going to earn this wage. You do this job, you're going to earn that wage. I think it takes out the incentive to be the better person, to really strive to be as good as you can be.
And could you explain, for those that may not understand, how this poster rule requirement could impact our country's small businesses?
From my personal standpoint, you're giving them all the information that says you can unionize. Here's all the people you can call if you're not happy. Here's all the things you can do if you'd like to be a union. But it never lets your employer say, hey, listen, let's step back and look at all the things I am doing for you. Maybe I haven't touted that I've been paying 50 or 75% of your total health care bill all along. Maybe I haven't told you that the union's pensions aren't really as strong as they'd like you to believe. but your employer doesn't get that same right. The NLRB would have you believe that they have firm hold on it. They have the ability to tell you how it's going to be, and if you have any recourse whatsoever, they're going to put their thumb to you. And the fact that we're exponentially increasing the time in which it goes to vote, and that there's going to be no secret ballots, you're always going to have weak people in this economy, and you're always going to have the stronger and the more pervasive. The stronger and the more pervasive are going to hold down the weak, and if you don't have a private secret ballot, like when I elect any of my congressmen, I don't want someone standing over my shoulder and judging me for the choices I have made. That is my democratic right here in this nation.
Thank you. And Ms. Melito, as you know, the proposed rule changes coming out of the NLRB seem to be anti-employer. Why do you think this board is particularly activist?
If I could go back to your earlier question, too, I just want to add one thing to Ms. McCauley's response, too, and point out, too, that the impact on small businesses are that they are now, as of November 14th, could, in fact, be in jeopardy of having an unfair labor practice filed against them. And I think it's very likely the board itself said that in its final rule, that we fully expect that many businesses will not be in compliance because they won't know about the rule, and therefore, technically they've committed a ULP. So I just wanted to point that out. Why the board has taken this activist approach and really unbusiness, made the businesses out to be the bad guys. I mean, I do think in somewhat, it's payback. Unions are declining. And right now the private sector, it's 7% or less than that. And it's a way, I guess, to try to, up the rolls, if you will. But I think it's unfortunate because it's coming at the expense of America's, largest employer, small businesses.
Thank you, Mr. Chairman.
Ms. Hahn. Sorry about that. Again, welcome to the committee.
Thank you, Chairman Graves, Ranking Member Velasquez. Thank you for welcoming me to this committee. I'm actually very interested in and really excited to be on the Small Business Committee because I think this is really becoming such a key focus for this Congress, and certainly it's a key focus for the American people. The statistics are out there. You all know them better than I do. Small businesses account for a huge part of our economy. They account for a huge part of hiring employees. We really believe, I know I do, that if small businesses, even the really small ones, would hire, even one person, we know that we could really reduce the employment rate in this country. And we know that that's the way to get our economy back up and running, is to get people back to work and to really support small businesses. And I hope what we do on this committee, and I know there's been some hard work already done, is really look at how we can support small businesses, how we can help them grow and help them hire. I will tell you, I feel it's a little frustrating to sit here. I feel like we're spending a lot of time on this poster. And I guess I would ask Ms. Melito, it sounds like you don't necessarily object to people knowing their rights, do you? I mean, what's wrong with employees knowing what their rights are?
It's not a matter of knowing your rights. I mean, certainly there's a right to free speech. Unions have a right to, talk with employees and have employees engage in concerted activity. As I mentioned before, employers have an explicit right under the National Labor Relations Act to certainly express their opinion about unions and, factually how it will potentially impact. I can't emphasize enough how far off the ranch the NLRB went with issuing this rule. It does not have statutory authority to issue such a rule. And in my mind, that's not a small thing. The poster itself is, yes, I agree, troublesome. Mr. Mittler quoted from it very nicely there. I do think it is biased and certainly, one-sided, if you will.
But is it saying anything that is not an employee's right?
No, it's not. But again, it's the way the board went about issuing a rule that it does not have authority to issue. Yeah.
Is there anything in that poster that in any way is telling an employee something that is not their inherent right?
No, but the board issuing the rule does not have authority to do, and certainly the punitive measures that will go into place for not posting the poster are dramatic and very, very problematic. You have a tolling of the statute of limitations for, the 6-month statute of limitations, which is indefinite, and you have an independent unfair labor practice. That is no small matter in my book. Again, these are businesses that do not have a human resource representative that's getting an alert from some human resource association out there. They're not going to know November 14th that they have to put this up in the break room with all the other posters up there, which, yes, the employees may or may not read. It's the fact that they don't have that poster up on November 14th. They have now technically committed an unfair labor practice, and they weren't even aware about this law. So where do the employers' rights come into? That's what's very problematic.
Well, and I appreciate you saying that, and I think what we've heard today is a lot of what you believe is the employer's right, and there's certainly many of us that also believe the employees have rights. Hopefully, it will not be something that once small businesses learn about the need to place this, hopefully there will not be objections to posting this poster. It seems to me a very small, as Mr. West said, you have a number of posters already that just allow employees to know what their rights are. And I think small businesses and the employers have plenty of time to talk to their employees about what their relationship is and what they can and can't do for each other. And I'll tell you, I spent last week in my district, I've met with over 50 small businesses. And I've given them questionnaires, and I've asked them to tell me, what regulations do you feel are burdensome? What can the federal government do or not do to help you? And what I heard was most of my small businesses never once mentioned any of these regulations that you're bringing up, never once mentioned why, having to post a poster or not. You know what they told me? They told me that if they could have more access to capital, that was their issue. And one of their issues was small business loans. And they felt like there was a small mountain of paperwork that had to be accomplished to get their loans, and that sometimes the criteria for a small business loan was simpler or less restrictive than what the banks actually were requiring small businesses to prove before they could access capital. So I'm going to work on figuring out how we can remove bureaucratic red tape to get more capital out to my small businesses, because that is what they told me overwhelmingly was the issue with the federal government. I will tell you, not one of them brought up what you're talking about to me today. So either those 50 businesses were not feeling that burden, or they just felt like the real priority they wanted Congress to work on was getting more access to capital. I yield my time back.
Mr. Schilling.
Thank you, Chairman. What I'd like to just kind of tell a story. A year ago, or actually it was last year, I went to a Labor Day parade, and as we were getting ready to march, there was a group of folks that were marching with the previous congressman. They had T-shirts on that said, "Big and small, check them all." I thought, what's that mean? Well, I realized what it meant, and for me as a small business owner, I have 15 years of union background, and currently I'm a small business owner. But and previously using the secret ballot, I truly believe that the secret ballot is our birthright, and that it should not be bypassed through card check or whatever ways or means that are decided. And I guess I have a question and I have a lot of friends in labor. I am not anti-union. I'm pro-business and I'm pro-labor, but it has to be an even mesh to where we don't put one side or the other out. And one of the things I wanted to ask Mr. West, with the small business, like mine, for example, do you believe, because a few weeks after this Labor Day parade, the congressman said to me that I should unionize my pizzeria in Moline, Illinois. Sir, do you believe that all businesses across the United States should be unionized, or just some, or?
I truly feel that there are some businesses out there that probably unionization would not benefit. But as far as like the poster goes, I do believe that's a fairness issue. You're posting for the employees what their rights are. Me as an employer, I have 45 people. I know every one of them by name. I know their families. I have contact with them on a daily basis. So I can put forth my issues as a business owner to them at any time I want, or their supervisor can. I think this poster is just a fairness issue. We're putting up a poster, and these employees can look and see the rights that they're entitled to. Whether they want to implement those or act on those, that's an entirely different issue, but I do think they should know their rights. But I also believe that there are certain businesses that have no need to be unionized, or that unionization would not be helpful.
Right, and I don't believe that anybody on the panel believes that employees should not know their rights. I don't see it. You know, one of the things I think some of the folks here would be shocked, being a small business owner, is that a lot of our small businesses have no idea that you can go online to pull this $85 poster up, because that's when they mail out. They mail out and you get all these special deals in the mail. But that you can blind dial to any business in your district and ask them, hey, do you know that you can get this poster for free? And I guarantee you half of them will tell you, no, I did not know that. As a matter of fact, I'm one that just found out today, and I've been in business for 15 years. So, you know, I think that it's about getting information out to people and doing it properly. One of the things I do have a question on this poster is now, because it is about getting information out to people. I mean, I think that's what we're looking at doing. It shows how to unionize. I haven't seen the poster per se, but it just shows, you know, what you need to do to become unionized. Is that what it basically is, Ms. Melito?
It provides information. I wouldn't say it provides information on how to become unionized, but certainly it indicates that you have the right to join a union. You know, you have the right to strike. It goes on. I don't have it all in front of me, but the litany of things that certainly you could do. Your rights under the National Labor Relations Act. And you're right, this is not about withholding information from employees. But it's about making sure that there's a balanced approach to labor law, which is the intent of the National Labor Relations Act, and ensuring that employers' rights are preserved. I would go back to Ms. Hahn's point there. She talked with 50 small businesses. Did she provide them with a copy of this poster? It would be nice if she had, because that's what I'm doing a lot of now. I'm getting this information out to my members. I'm not a registered lobbyist at NFIB. Most of my job is to provide education and compliance assistance to our members. I'm working the dickens right now to get this information out to my members. Make sure they get this poster up. You know, you need to get this up. You need to be in compliance. Yes, we have this lawsuit going on, and I do hope the court is going to strike down the law. But at the same time, I want to make sure that our employers know that this does need to be posted. Our members want to be in compliance with the law, and if that requires them to post this poster, you know, so be it. But they want to be in compliance. They want to do what is required under the law. They don't want to violate the National Labor Relations Act, the OSHA law, the wage and hour law, or any of the other laws. They just want to be told what to do. So it's trying to get the information out to both the employers and the employees. Thank you.
Very good. I just want to thank the panel for being here, and I yield back my time.
Mr. Owens.
Thank you, Mr. Chairman. Mr. Mittler, in your testimony, you indicate that in 31 years, OSHA has come to your shop twice?
That's correct.
When was the last time?
It was sometime between 2004 and now. I don't recall exactly when it was. But I know we moved into the present facility we have in 2004, and they visited that building once.
You also indicate in your testimony that you say in the past an inspector or auditor would visit our shop and work with us to correct any unintended violations. Today they fine you first and take no questions later. Were you fined on that second visit?
Yes, on both visits we were fined. Yes, we were.
Now, how many years ago did the first one occur?
I did not look up the history of that previous to that, but it was a number of years prior.
So basically the procedure didn't change then?
The procedure has changed in recent years.
Well, if you got fined both times.
From 2004 to now, the fines have increased dramatically, and the ability, in both cases, if we agreed to correct the violations, and we corrected them in a timely manner, which I believe was 90 days, and then we submitted proof of correction, which we did all those things, then the fine would be half of what it was, what it was initially proposed. So we did not fight the violations. They were relatively minor. We corrected them. Some of them we corrected within 24 hours Some of them we had to order some parts and pieces from the manufacturer of machines and get them in. And then we installed that, sent the documentation to the inspector, and he said, yes, you've met it, and we will reduce the fine in half. I'm told now by fellow shop owners that there is no reduction of the fine. The fines are doubled what they were, so what was a $1,000 fine before is a $2,000 fine today. So there's where the change is. The change has happened from 2004 till now.
And that's based upon what you've been told as opposed to your experience.
That is correct. However, I have many, as the chairman of NTMA, I have many friends and associates in the business who have related these stories to me in a factual manner. But
I can tell you that having represented many small businesses before I came to Congress, as a regular course of my practice, I was successful in getting reductions in fines, and I'm having a little bit of difficulty believing that that is a consistent trend that exists throughout the United States. I'm just curious also, there seems to be a general objection, if you will, to OSHA regulations. Is that true or not true?
There's no, I think some OSHA regulations are far overreaching for us as small business because we don't have sufficient staff and all that to really be able to help us interpret the law and know what all the laws are. I think knowledge of the law is a difficult thing. If I was not active in our trade association, I would not be knowledgeable that I would have to post this poster. I don't know that it's been published in the paper or in any other place that I have to do it. So I think knowledge and some of the laws and rules are overbearing.
Now, you say some. How do you distinguish between the gradations, and which rules would you strike down, which rules would you keep, which do you see as reasonable?
I don't have any case in point there that I can speak to. I just mean in general what impacts a company the size of Boeing and what impacts the company of our size with 60 employees, you would certainly think would have to be different. I have 60 employees in my facility. They have thousands of employees. So naturally, more protection is needed there, just in general. I can't cite any specific case.
Do you think Boeing would agree with that?
I think for the most part they would be concerned about the safety of their employees. I think they are. Yes, I think they're very concerned about the safety.
No, I'm not suggesting they're not concerned about it. I just meant that you feel that they should be more regulated than you. That's where I thought.
They probably don't agree.
They probably wouldn't agree with that. I didn't think so. Ms. Melito, you made a statement in the course of a response to Congresswoman Hahn's question that your business, your members, do not have HR directors. As they're too small to have that level of service. Is that true for every business that is a member of your organization?
No, certainly not all of certainly not all of our members. The vast majority do not have a human resources director.
What's the general size of the businesses that are in your?
10 employees or less.
10 employees or less.
Yes.
But there are some that do have HR directors.
Some of the larger ones, yes.
And do some of them also participate in? Do you know, in groups? What I would call buying groups, where they purchase HR services out of a buying group?
I don't know the answer.
Is that a service that you offer?
We do not offer that service to our members.
Do you provide general information to your memberships, for instance, about the issue regarding the poster?
Yes, we certainly do provide, we try to provide some educational and compliance assistance to our members on general employment law matters.
Now, would you provide them with a copy of this poster and the information relating to its implementation?
We have the information available on our website, and it most definitely includes the link to download the poster, and we certainly indicate on there that it is free. We have made all that information available to our members.
And do you send out a general, if you will, blast email with regard to this type of activity, not just related to this poster?
We do try to alert our members to new rules and regulations, certainly, and this has been sent out in our e-newsletter to our members.
Thank you. I have no further questions, and I yield back.
Mr. Mulvaney.
Thank you, Mr. Chairman. And for those folks who are here are wondering why we're talking so much about the poster, you know, I've run a couple of small businesses, and I can tell you that quite legitimately, small business people fear these things. We do. I did, because quite simply, I was always afraid that I didn't have the right ones on the wall. or I didn't have the one that was up to date, or that I was, to this point before us, missing one, that somehow the government had come out and required me to put up a new poster and forgot to tell me, or I didn't find out. I didn't join NFIB to find out whether or not I needed posters or not. I was too busy running my business to try and follow the regulatory actions of the Federal Government. And, of course, if you don't have the right ones, you're in a lot of trouble. You could be fined, you could be penalized, you could be in a lot of trouble. In several states, I think it's negligence per se not to have these things up on the wall. So it is a serious issue to small businesses, and for that reason, I'll continue on this topic that some folks might find to be trivial. Mr. West, you mentioned before you think employees should have the right to, that they should have the right to know what their rights are, right? I think that was your testimony.
Correct.
That was you liked the poster, you got no difficulty with it, it's free. How did you find out it was free, by the way? I always paid for these things. How did you find out it was free?
It was posted through the Sheet Metal Workers International when we, in one of their little blurbs, that this was a poster required and it was a free download.
Gotcha. Did you pay for the other ones, by the way?
No, yes, I did. The OSHA ones you do pay for.
And the minimum wage ones you pay for.
And the folders, yes, you do pay for those.
You know, they've also got the right to quit their union. That's mentioned in very small print in the document. Do you think it would be a good idea to talk more about that on the poster?
Well,
it's their right, isn't it? We go into a long list of how you join a union. Don't you think there should be some balance there and show how you get out of your union if you don't like it?
Well, I think if that is taken care of at the union level. They go through their procedures, so it's pretty easy to get out of a union. You just stop paying your dues.
Yeah, but the whole idea behind this is to let employees know what their rights are as employees. They have a right to join a union, and if you want to join a union, here it is. This is how you do it. So why not have the same thing on there about how to get out of your union?
I would think if you were that concerned about it as an employer, you would put your own piece of literature together and state your facts and put it up beside it.
What if you were concerned about it as an employee? What if you were an employee who just didn't want to be in the union? Where would you go? I mean, where else would you go to find out how to get out of your union?
I would assume once you start the negotiations, you vote not to join the union.
Right, but wouldn't this poster be a great place to put it there? It's there in your lunchroom.
I wouldn't have a problem with it. I didn't design the poster, but I mean, you know. But I do think the employers have the upper hand as far as the negotiations.
These employees have got other rights, too. They have rights to free speech. They have rights to Second Amendment rights. Can we put those on the poster, too?
No, sir.
And why not?
We should already know about those. We have a Constitution.
Exactly. So why is it that we have this document that shows them rights that they should probably know anyway?
Well, my feeling of this whole issue is it's just a poster, and if the idea of this is that the NLRB has been so successful and is so biased toward unionization and organized labor, how come for the last 3 decades all we've done is lost membership?
Because this poster hasn't been around for the last 3 decades.
I don't think the poster is going to make a whole lot of difference. I think we're wasting a whole lot of time on it.
Now, there's other things that list here. It says under the NLRA, there's a long list of things that it's illegal for your employer to do. Which I guess is fine. Don't you think maybe then in order to have some balance, we should have a list of things it's illegal for the employee to do? It's illegal for you to do drugs. It's illegal for you to harass other people. Or do you think they should know that anyway? I
have a poster similar to that. We, in our, out of Sheet Metal Contractors Association.
Is that required to be put up by the NLRB?
It is not.
Do you get fined if you don't put that poster up?
No, sir, I do not.
Do you think the NLRB should be balanced between employer and employee? Or do you think the NLRB exists to defend the rights of the employee against the employer?
I'm certainly not an expert on what the NLRB does, but I would assume that it is there to generate fair and equitable labor practices. And if they're doing that, then I'm assuming that they're doing what they were designed to do.
If you're an employee and you're dissatisfied with the way you've been treated, if you think your rights have been violated, you get free legal representation from the NLRB. Do you think if you're an employee, an employer who has been wronged by the employee or even by the union, that you should get free legal representation from the NLRB?
I don't think you would.
You don't, under law. I'm just wondering if you think that you should. You're an employer. If you thought your unions had wronged you, that they struck you legally, do you think that the NLRB should represent you, give you free legal representation in that claim against your union or against your employees?
I don't think they give free legal.
I can assure you they don't.
They don't give free legal advice to the unions either. The unions hire their own legal attorneys, And so as a signatory, if you're wrong, you should hire your own attorney. Employees are a little different level, I would think. Maybe an employee doesn't have the financial wherewithal to hire an attorney, so I could not have a problem with them giving an attorney to an employee.
All right. And finally, do you think I should have to join? Don't get me wrong. I love the NFIB. I love small business associations. Do you think I should have to join the NFIB in order to know what my legal obligations are as an employer?
I do not.
Are you a member of the NFIB?
I am not.
Thank you, Mr. West. I appreciate it. I yield back the balance of my time.
Thank you very much, Mr. Chairman, and I'd like to thank our ranking member in absentia. I'd like to thank our panel for their testimony today, and got here at a point where there was a lot of discussion about this poster, and I wanted to direct my comments to Mr. West. There's been much talk today about the detrimental effects of unions on small businesses. I'm going to assume that you weren't awarded contracts with Lockheed or Howard Hughes Medical Institute while being plagued with workers content with having a job that pays a living wage and provides health care, who are giving you the bare minimum with regards to craftsmanship, effort, and professional pride. However, could you tell us what would happen if your business if this were to be the case?
Well, basically, I have built my reputation here in this town as a contractor. We do the very difficult and the specialty type jobs. So maybe I'm a little unique, but I have some very special workers that are highly skilled, and I get called for some very high profile projects. So I would be out of business if I were to lose that highly skilled workforce. Now, we do compete every day on some of the lesser skilled jobs and against contractors that are open shop, that do not provide health care, pension plans for their workers. So we are at a little disadvantage when we compete against those folks. But there's been several occasions where we do get hired after a project has been done to come in and clean it up and bring it up to standard.
Very well. Thank you, Mr. West. My question to the rest of the witnesses is this. We have a small business on the panel who has survived these trying economic times and is still operational with high-profile clients, and who successfully exists within the same small business environment that you all operate in, who insists that these new rules will not affect him adversely. If it's simply a situation where you do not want unions in your businesses, I can at least understand that. However, I'm going to need to have a couple more dots connected for me to understand how this adversely affects small business. And if time allows, would you just sort of give me a sense of what Mr. West is doing that perhaps you could not use as a part of your business practice?
Well, I think that it would be a detriment. I would prefer not to have a union in my company. We haven't had one for 32 years, and we have, like Mr. West's company, been very successful over the years. During the downturn, it was very difficult. It was very difficult. My brother and I took personal wage cuts to keep our highly skilled employees employed. We didn't send them back. We don't have a union hall. So we have to maintain our employees in good times and in bad. Yes, did we have some reduction in force? Absolutely we did. But we did everything we could to keep our highly skilled employees because we have a vested interest in them. They have a vested interest in our company. So I'm not suggesting that unions are a bad thing. I just think for our company, it's not the preferred way to do business. And I'm certainly not against my employees knowing what their rights are, exercising their rights in any way, shape, or form. What I want to be able to do is keep that open communication with my employees. I want to be able to hire the employees that I see fit. I want to be able to man the jobs in my plant as I see fit with the employees that I need in the different skills level. The other thing that is important for our company, since we do a lot of different types of work, we have precision machinists, welders, electricians, general assembly people. During those tough times, we moved people, we cross-trained our people, and we moved them into different jobs as the ebb and flow of the work changed. And so typically we see in union shops, you're classified as a machinist. Therefore, their attitude is, I won't do other type of work. I won't do assembly. I won't do machine maintenance. I'm classified as a machinist. So we need that flexibility in our business to be able to keep our people employed.
And that's your particular business model, Mr. Midler?
Yes,
and
it is.
You, of course, compensate your workforce accordingly.
Absolutely.
Right? Cross-trained and everything.
My highest skilled people have the highest compensation. Absolutely,
Fabulous.
they do.
And I'm going to wrap up, but Ms. McCauley, did you want to add anything?
The only thing that I would add is I find that it's imperative, just like Mr. Mittler said, that you have employees that you can cross-train. That's where we make profitability in a small business. I might have an employee that can lay brick, but I also might have that same employee might be able to pour some concrete. He might be able to throw rebar in the wall. He might also be able to strike that wall too. Now, if I were a union shop, my bricklayer wouldn't be able to strike the wall. He'd be able to lay it in place. He couldn't lay the block. He couldn't pour the concrete, and he couldn't pour the rebar. So I'd have to have 5 different employees to do that same function of that one employee. It's imperative that we have the ability to cross-train our employees. When you have a limited staff, 5 to 10 employees, and a lot of us, just like Mrs. Melito said, a lot of her clients are 10 or less. A lot of mine are the same. But I've cross-trained enough of my employees that one guy can do the same job as 5 union workers, and I wouldn't have that same ability in a small business.
I'm sure that helps with our unemployment. Mr. West, don't you have a similar?
Well, I just think that's a little misconception there about the how they departmentalize union work. I run a production shop. We do field installation. We do welding. We do testing and balancing. Every aspect of my job, the same person can do that. They're trained in the aspects of the trade and the industry, not one specific job. So I don't think that I think that's a misconception that if you have a union bricklayer, if you're going to run a small shop, he's not going to lay block, he's not going to mix the mortar, he's not going to put the rebar in. That will not happen in a small shop. They're partnered with the business. It is in their interest to keep their job just like it is in an open shop.
Thank you. I appreciate all of your response. I'm over time. Thank you, Mr. Chairman.
Mr. Shabbat.
Thank you, Mr. Chairman. Ms. McCauley, you were talking before about the various kinds of employees there are. You mentioned that there are some slackers, there's some non-slackers. You mentioned you have 4 boys, and some are slackers and some aren't. I was just wondering, which of your boys are slackers?
The 3-year-old.
The 3-year-old.
He can't pull his own weight.
Oh,
we'll get there.
All right, sounds good. Now my serious question. Relative to, it seems what you're talking about here is kind of a basic fairness. They're requiring certain things to be done for which there could be significant penalties if you don't put the proper poster up in the right place, the right size, at the right time, et cetera. And it seems like most of the burdens tend to be on the employer. I'd ask any of the panel members if you could maybe go into that a little more detail about what kind of burdens are there on the one side but not on the other side. Where is it unfair? And we can start with you, but anybody who wants to take it on is fine.
The last company I worked for, I worked there 20 years. We had 300 employees. I was an HR director for that company. There is not a site you can go to that gives you all the government postings. There is not a site that says, okay, if you're a small business, you need to post this, 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 and this. There's no blast emails, for better word, that go out and say, hey, just so you know, I realize you're a small business. I realize you're registered in your district or you have your Class A license or whatever. You need to be aware of the sweeping changes that are right before you. There's nothing like that that goes out. Even as an HR director, even though I have my license and all that good, there's nothing that goes out to let you know. If there was a website that everyone was aware of that listed new postings that you needed to have up, hey, this one expired, got a new minimum wage. We've got some new OSHA law. I think a lot of people would be very happy to post those because they'd be aware of those. I think the biggest fear of small businesses is unaccounted for expenses. Unaccounted for expenses that don't lead to any profitable measure, that are just fines and penalties. I think it would be very helpful, and it would lead to a more cohesiveness if everyone had the ability to look to the same place to know what the laws and regulations were.
Okay, thank you. Anybody else have any comment?
Yes, sir.
Okay.
I would just like to say I agree that there should be a website where all that information is made available. But I'm also a little confused here is who enforces this poster law? Who comes to your business to find out whether you put the poster up or not? I'm a little confused on that.
Mr. Miller?
I certainly don't know the legal answer to that. I think that, and we discussed that today, where is the hammer for any of us? And I think where it would come from would be a disgruntled employee or employees. They would say, hey, that union poster isn't up there. And then, then they would possibly go to the NLRB or something like that. Ms. Melito obviously is better prepared.
Yeah, that's exactly how you've got it right. Exactly. Yeah, it would be an employee, probably a disgruntled employee, who would learn about the poster and then file an unfair labor practice charge with the NLRB. That's how it would start.
Okay, and that's what I wanted to follow up with at this point, because I've only got a little over a minute time left. If you don't post the signs, and I know you had mentioned that many small businesses obviously don't have an HR department. They're just too small, and some do, but lots of small businesses don't. So for somebody like that who didn't even know about this and didn't have it posted, and an employee or somebody comes up and files an unfair practice against them or whatever they do, what are the potential penalties for that, and what are the potential ramifications to that business if they do have to deal with one of these matters?
Well, certainly as an initial matter, the board would demand that the employer post the poster too, but it would also open the employer up to additional scrutiny too, and the potential for other unfair labor practice charges if there were other things going on in the business that would, the employee could argue were infringing on their, the right to concerted activity. So the employee could then, file other complaints too. So it could open up a whole can of worms. And I think upon receipt of ULP, it's very likely the small business owner would quickly call an attorney, so you're looking at additional, potential legal expenses too in defending the claim.
Okay, thank you. And in the last 10 seconds I got, let me just commend the chair on holding this hearing, because at these tough economic times when 70% of the jobs created are created by small businesses, we need to find ways to relieve some of this burdensome regulations and requirements. So my compliments, Mr. Chairman.
Mr. Keating.
Thank you, Mr. Chairman, and I'd like to thank all the witnesses for being here today. As we sit here and we're attacking the National Labor Relations Board rules, we're missing one more time that we can really deal with some of the critical opportunities that are actually creating jobs, that can create jobs and create small business opportunities. Just last week, the House passed H.R. 2587, which inevitably will result in making it more difficult for workers to have a means to protect themselves from illegal practices in the workplace. Now, as someone that considers themselves a strong, outspoken proponent of small businesses, it's worth, I think, remembering that unions weren't formed to be obstructionist, and the facts, I think, prove that any fear along these lines is unfounded. According to the Bureau of Labor Statistics, only 7.2% of private sector employees identified themselves as members of a union in 2009. That compares with 9% in 2000 and really healthy digits, double digits, back 40 or 50 years ago. So as we sit here today and we're talking about things that, as a committee, will create new jobs, I think we should keep in mind that most small business owners in the United States today won't even have to interact with a union. But while I am on the subject, I just want to state, too, that the NLRB rules are common-sense proposals, and they're designed to ensure fair process for the workers by cleaning up and modernizing a system paralyzed by delays, bureaucracy, wasteful litigation. And the proposed changes aim to provide greater stability, greater certainty, and a leveler playing field. I think we've seen countless examples where high-cost litigation and intimidation have been used to stop workers from effectively organizing. But I think we can all agree that our country was built on democratic principles. So what is against democratic processes being used to utilize resolving issues in the workplace? Now, I spent last week, a great period of the week, talking to owners of more than 12 small businesses and about a myriad of issues. And not once in the course of those discussions did this issue come up. Maybe it's just the people, maybe it's my district, maybe it's the people, but not once did this come up. A lot of other issues came up, issues that they said were the important issues that they faced, issues like loan guarantees, tax credits, grants, SBIR funding, for instance, came up. Now, how would you rate these? And I think it's really a question of perspective, and I think that's what I'm trying to gain by this, by my question. With all the things you have as issues, is this rate, I don't understand how it rates so high to draw this kind of attention. Aren't there other important issues? And if you want to take the opportunity, can you tell me what those other important issues that we can be doing in Congress to help might be? I'll throw it open to anyone.
I'll start. Like I said before, I do believe it. Oh, turn it off. Thank you. I do believe it is a slippery slope. I think, like I said before, not very many of the small businesses that I spoke with had any clue that there had been a change. I know a whole bunch of people, landscapers, all kinds of different people in my area, and I asked the question, do you know this is going on? Do you know you need to post that? I've never even heard of it. Why haven't you heard about it? It's the first time I've heard about it. So I think it's hard for people to have an issue with it if they don't know it exists. And I think I agree that funding is very important. I don't discredit that it's very important to be able to find loans and help to garner the ability to just increase the workforce we have and grant more people jobs. I think until we can get the ball rolling and get more people employed, we're just really just scrambling. That's what's going to take to get us out of our deficit, just like anything else. The more people that work, the more taxes are paid, the better we all are. So if it's small businesses that are really garnering the most new jobs, then I think we really need to take out a lot of the bureaucracy, and I think a lot of it stems from unfair fines and penalties for things you don't even know about. I realize I'm not dumb, that ignorance of the law is not a defense, but it also shouldn't be the reason things get through. It also shouldn't be the substance behind how we raise capital.
Anyone else want to jump in as to what, in ranking what's really important right now to get new jobs and to help our economy go forward? Do you really think this ranks right up there? I just, not one person. If those people were, and I went through a lot of people in a lot of sectors, not just last week, but the weeks before, I made a point every time we have a week off to go visit business. And I've been across the board, manufacturers, large business, medium business, a lot of small businesses. Not once did this come up. I'm just curious.
Pardon me. I'm certainly not suggesting it is the top issue in small business today. It is an issue, and I think, as Ms. McCauley said earlier, the slippery slope is what we're concerned about. What we give away today, what is taken away by rule that, as Ms. Melito said, in her opinion, it is not even legal for them to impose this on us. What is taken away today, then what will be taken away tomorrow, next week, next year, and so on and so forth. Certainly the unknowns of the future is a big concern. I'm fortunate that our business is growing. We have hired people this year, and certainly what the tax rate will be and the impact of the deficit is a huge issue and burden for us. And certainly, given the opportunity to come back and speak to this committee or any other committee on that, I think you would hear a lot of other testimony.
Well, thank you, Mr. Chairman. My time is up, and I do thank Ms. McCauley, because you hit it right in the head, though. The best way to deal with the deficit is to get some more jobs going. Thank you.
Absolutely true. But I thank you for taking the time.
Well, I want to thank all of our witnesses for being here, and I personally think definitely want to agree with Mr. Mulvaney. I think this is heavily weighted towards demonstrating the rights to be able to unionize, but it doesn't do a very good job of putting the rights out there for the employees, the other rights that are available to them when it comes to being able to get out of the union. And I also want to agree with Mr. Keating, too. I think being able to solve some of our relations between employers and employees should be a democratic process. And one of the very basic principles of a democratic process is secret ballot. And being able to determine whether or not you want to unionize or not unionize by secret ballot is a very important basic principle to that. So with that, I would ask unanimous consent that all members have 5 legislative days to submit statements. Seeing no objections, so ordered. With that, this hearing is adjourned. I thank you all for being here.